For our podcast disclaimer, please visit the episode description. Thanks for joining us here at What the Heck is Happening in HR. Today we're going to talk about an amendment that was in the funding for the omnibus bill. We have a few of them to discuss, but today we're going to talk about the Pregnancy Fairness Workers Act. And you might go, well, wait a minute, we already have a pregnancy program there. It's Pregnancy Discrimination Act that was passed back in '78 that prohibits employers from denying jobs or other opportunities due to pregnancy, childbirth, or related medical conditions. So we already have that. And why do we need something else? Well, this is a little different. This one talks about accommodations for job applicants and employees, and it requires employers with 15 or more to follow this. And what it is that they must provide pregnant employees with reasonable accommodations. You may remember that from the ADA, that do not cause an undue hardship. Again, ADA language. So let's go back again to the Pregnancy Discrimination Act. It provided Title VII protection, where you couldn't treat pregnant workers differently than anyone else who has a similar ability or inability to work at that same job. It didn't protect, though, pregnancy-related illnesses like blood pressure, morning sickness, things like that. So many requests that were made have been unanswered. And part of that is because we want to do the right thing. We don't want somebody else wanting to claim something. So we go, well, we don't have to. Well, as my granny used to say, just because you can doesn't mean you should. But if you can, why wouldn't you? So we want to talk about accommodation in similar roles. So ADA language. Reasonable accommodation means that the essential functions cannot be eliminated. That means that they must be able to do those jobs. So what would be a reasonable accommodation, perhaps for somebody who is pregnant? It could be needing a chair if they have a job that stands up. It could be extra breaks. It could be that they need to walk around. It could be a review of heavy lifting and what lifting would be required. It could even be a transfer of minor duties to somebody else. But the essential functions could not be eliminated. So what does undue hardship mean? It means it's a burden. It means that it could be a financial burden. It could mean that there could be additional people that would be needed. The type of operation might not allow for it. It could be just the nature of the business. It's something that means it's unreasonable for it to happen. So reasonable accommodation and undue hardship are both part of that Americans with Disabilities Act and are now part of this Pregnancy Fairness Workers Act, PWFA. It's like ADA, but it's temporary. And you must be pregnant, so it's not a disability. So who's enforcing this? The EEOC. And so what should be happening? Because this will be taking place in the next 6 months. You want to be sure you watch the EEOC for guidance. You want to check for updates, and you will need to plan for some training. That is something that you are going to need to do with this plan. So, Pregnancy Fairness Workers Act, you know about it. You've got 6 months to prepare for it. We hope that you'll be expecting to get those new podcasts every Monday morning, and we appreciate you listening. Get your podcast on any of the platforms and subscribe today. Thanks for listening to What the Heck is Happening in HR.